Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor, Law Center 2, Faculty of Law, University of Delhi. Well friends, we will today start with our 8th module of the course Maritime Law, and we will start discussing about navigation and safety. So far we have covered two major parts of maritime law, one belonging to historical development along with law of the sea. What are the rules, regulations and laws pertaining to law of the sea? How do we regulate ships and coastal estates as far as their interaction with sea is concerned? We also dealt with admiralty laws in the last 3 modules to satisfy the claim, but in today's class we will see that how ships also gain nationality just like individuals, and when they have nationality, what are the benefits or advantages that ships are endowed with, and therefore we will see an extended application of the nationality aspect as well, where the ship is considered to be a juridical personality or a legal personality. And therefore we now come to our third set of modules, wherein we will talk about navigation and safety, and we will also in the further modules talk about shipping laws in India, how in general navigation and safety is in place in order to ensure proper navigation, safe navigation, sound navigation, in order to ensure that sound ships, seaworthy ships are sailing from one part of the world to another part of the world, in order to ensure that ships are not polluting our sea, in order to ensure that ships are not causing harm to living and non-living resources present or available in the sea, in order to ensure that ships are not harming other ships, people, goods of any nature, perishable or non-perishable. What kind of rules and regulations are made available for ensuring that ships navigate properly and also to ensure that they navigate safely. The safety of not only living and non-living resources of the sea is taken into account, but also we have to take into account largely and primarily the safety of the people traveling through sea routes from one part of the globe to another part of the globe. We have to also take into account the safety of the goods that navigate from one part of the world to another part of the world. So the traveling through sea has to be ensured by the states or individual state, when the role of individual state comes into being, that such ships sail safely, they navigate safely. So therefore we will talk about different players, different stakeholders as far as navigation part is concerned. We will talk about different subject matters, not only about ship or not only about the people who are traveling through those ships as passengers, but we will also talk about the safety and security of the individuals, that is the crew members which form part and parcel of the ship. How to protect their interests also falls within the domain of navigation and safety aspect. So therefore friends, let us look at the learning objectives for the day, and it would be to learn about National Shipping Board and National Welfare Board of Seafarers. As I said, that navigation and safety are required not only for ships but also for the crew members, and therefore we have a policy making body which is known as National Shipping Board. The primary role of the National Shipping Board is to frame larger policies as far as shipping activities are concerned, navigation through ships are concerned. After larger policies are framed, we see that central government through its primary body, that is Director General of Shipping, executes all those policy that are being framed by the National Shipping Board. So, in order to implement and execute and enforce those larger policies with respect to safety and navigation, Director General or DG Shipping is responsible enforcing body which takes care of day to day functioning, framing of rules and perform all other activities as required by the central government. It, for example, it has framed manual with respect to safety and navigation. It has prepared manual with respect to implementation of international law in domestic legal system. So, as far as India is concerned, we have National Shipping Board which takes care of policy making decisions as far as shipping, navigation and safety is concerned. Further, we have National Welfare Board for seafarers which takes care of the interests of the seafarers, that is largely the crew members, as far as their employment is concerned, their gratuity is concerned, their provident fund is concerned, their other aspects of employments are concerned. So, in order to create security in the minds of the crew members with respect to their employment, we have National Welfare Board for seafarers. So, we will discuss both the national board's constitution and its primary function as far as their policy objectives are concerned. Secondly, to understand the concept of nationality of ships. Well friends, nationality of ship is very important for the very reason that since ships travel and sail from one part of the world to another part of the world, and therefore, in order to have a kind of protection, every ship requires nationality. We have in the previous classes talked and discussed about flag state jurisdiction. What is this flag state jurisdiction? A ship can sail with a flag of whose nation or of whose state it is carrying the flag. So, if there is a ship that belongs to India, or if a ship is having a flag which has been put upon the mast of the ship and it is tricolor, where it is Indian flag, then it will be deemed and understood that it is an Indian ship. The nationality of the ship is Indian, and if Indian ship is having protection in other country, then or if it is recognized by other countries, then that particular ship will have the benefits of being an Indian ship. At the same time, it might have certain disadvantageous repercussions also if the relationship between two states are not good or are sour, or there is lack of reciprocity as far as the two nations are concerned. In such situations, there is at least a predictability that a ship should avoid reaching out to the ports where the relationship between country A and country B are concerned. So, therefore, we will also talk about the nationality of this ship. Third objective for today's class would be to learn the process of registration of ships. Once a ship is registered, then we can say that it is the national of that particular country. But then it is not so easy that or what is the process of registration. So, we will discuss in today's class the whole process of registration, what are the certificates that a ship has to obtain, and only then we can say that a particular ship is registered in a particular country and it can then raise the flag of that particular country. Well friends, we must also note here that registration differs from construction. There are countries that are not scientifically advanced, or they do not have the capacity, or they do not run the construction business as far as ships are concerned. A ship may be constructed in UK and may be registered in India. A ship may be constructed in France and may be registered in Italy. So, the registration part is different from the construction part. So, the nationality or the identification of the nationality of the ship is not dependent upon the construction of the ship. It largely depends on the process that has been adopted, process that has been followed as far as its registration is concerned, and only then it is eligible to raise and fly the flag of that particular country where it has been registered. Well friends, we cannot talk about the registration process of all the countries, but we will certainly in today's class talk about the process of registration that takes place in India. So, today's lecture would largely be focused on Indian rules and regulations as far as nationality of ships and registration of ships are concerned. Moving further, let us go through a brief historical background as far as the topic of the day are concerned. Therefore, India has been a seafaring nation for centuries. So, when we say that India has been a seafaring nation for centuries, we must realize also the fact that when we talk about construction or flag state jurisdiction, the idea of flag state jurisdiction is something which comes into being post medieval times and at certain instances pre medieval time also, but largely it got developed and accepted, and the quantification of this particular practice getting accepted comes into being only post medieval times, and in modern times it becomes a rule which is customary also in nature, and also at the same time it is now codified as well. But when we talk about India, as we have seen in the historical background lecture of the first class of this particular course, we note here that since Chandragupta times or Mauryan Empire's times, or even before or after that in ancient times, we see that Indian ships had reached out to other places of the world. That means these Indian ships, either from the Chola Empire or Pandyan Empire, we see that were constructed in this particular part of the world, and therefore we can say that it is not that India was not or never having a construction regime as far as ships are concerned. Ancient times, India was one of the cradle of transportation, or you can say trade related aspects, and therefore when we talk about the history of India as far as India being a seafaring nation is concerned, certainly we note that construction of ships used to take place in India. It is only post invasion by the Mughal era and the Britishers that the development and advancement was somehow halted at that particular point of time, and for that particular longer period of time we see not so development happening as far as, or not much development happening as far as this particular subcontinent is concerned. Therefore, we can say that India has built up a glorious maritime history and tradition much before the rise of European maritime powers. The Indian ships used to sail across many seas and carried on prosperous trade with Asian and Middle East countries. The source for this particular information has been dealt in the first module itself, wherein I have quoted R.S. Marsden, where in his archives he has noted instances of Indian navigators reaching out to Greek or Roman empires. Since the advent of British rule, the development of indigenous shipping industry was discouraged because of preferential treatment given to British shipping. The restrictive British navigational laws not only hindered the growth and development of Indian shipping, but gradually made it disappeared from high seas. The Indian merchant shipping law as it existed in 19th century has never been on sound footing. The British law was applicable to Indian ships trading in international sea voyages, as these ships were required to be registered under UK Merchant Shipping Act, and therefore technically they were British ships although registered in India. The Indian merchant shipping law was nebulous and sketchy. Between the years 1938 to 1947, the following legislations on merchant shipping were held the field, that is the Bombay Coasting Vessels Act 1938. Secondly, the Indian Registration of Ships Act 1841, which was amended in 1950, and the Indian Merchant Shipping Act 1923. In the present time, we have Indian Merchant Shipping Act or Merchant Shipping Act 1958. The first of the three enactments referred to above dealt with regulations of sea-going vessels. The 1841 Act embodied in it provisions relating to registration of sailing vessels. Both these enactments had, however, been so modelled as to apply only to small coasters and sailing vessels. The third act, namely the Indian Merchant Shipping Act 1923, was fairly comprehensive. We see that Indian Merchant Shipping Law, consolidating the provisions of the earlier two acts, was supplemented by passing of the Seamen Litigation Act 1946 and Control of Indian Shipping Act 1947. This act had, however, only consolidated the laws on merchant shipping, and it did not revise the law, and therefore was found wanting in many respects. The provisions of the International Convention with respect to load lines 1930 and SOLAS 1948, SOLAS here implies Safety of Life at Sea, 1948, an international convention, both of which were ratified by India and were later on incorporated through Indian Merchant Shipping Amendment Acts 1933 and 1953. Even in the Merchant Shipping Act 1958, we see the implementation of provisions of Solas Convention or Load Line Convention in Merchant Shipping Act itself. Immediately after the independence, to suit the requirements of a maritime country like India, the Merchant Shipping Act 1958 was passed by Indian Parliament. This act had made good the main deficiency in the earlier laws, that they did not provide for registration of what may be termed as Indian ships. Certain enabling provisions were also incorporated in the act to accelerate the pace of development of shipping in the post-independence period. This act is divided into 24 parts. So, when you look at Merchant Shipping Act 1958, it has been divided into 24 parts, each part dealing with different aspects. Let us say some parts are dealing with charter party agreements, certain part is dealing with safety, certain part is dealing with safety of pilgrimages, certain part is dealing with cargoes. So, different parts are dealing with different particular aspects in order to regulate the concerns of navigation, shipping and safety. Each part dealing with specific aspects of merchant shipping, like registration of ships, sailing vessels and fishing vessels, National Shipping Board, manning of ships, engagement, discharge and repatriation of seamen and apprentices, safety of passenger and cargo ships, control of Indian ships and ships engaged in the coasting trade, collisions, prevention and control of pollution of the sea by oil from ships, limitation of ship owners' liability, civil liability for oil pollution damage, etc. And friends, we will touch upon the important portions or important chapters or parts of Merchant Shipping Act even today as well as in the upcoming modules as well, wherein we will try to understand the main parts of the Merchant Shipping Act in detail, and how Merchant Shipping Act through its various provisions and parts tries to protect life at sea, cargoes at sea, how it ensures that ship should be seaworthy before it goes on sail, and other portions such as how to protect sea from oil pollution, what type of liabilities to be incorporated or what type of liabilities to be enforced against those ships that have committed the damage. Such aspects would be dealt in the upcoming modules and as well as today as well also. The intent and purposes of the Act. The intent and purposes of the Act is explained in the preamble to the Act, which is as follows. An Act to foster the development and ensure the efficient maintenance of an Indian mercantile marine in a manner best suited to serve the national interest, and for that purpose to establish a national shipping board and to provide for registration of Indian ships and to generally to amend and consolidate the law relating to Merchant Shipping Act. So, what we see here is largely the purpose is to establish National Shipping Board, which will frame the policy or will take care of the policy matters, and then to provide for registration of Indian ships. As I said, registration is very important for the very fact that if a ship is not registered, it cannot be considered to be a seaworthy ship. Also, it will not be able, especially in India, if it is not registered, then it will not be able to take the ship with an Indian flag. So, if a ship is to be recognized and wants to receive benefits of being an Indian ship, then it must follow the process of registration that has been mentioned in the Merchant Shipping Act. And therefore, we see that the institution that are established under the Merchant Shipping Act 1958 primarily, as we see, is National Shipping Board, which has been established under section 4, and under section 218 National Welfare Board for seafarers. Seafarers are the people who travel far long distances from one part of the globe to another part of the globe. Therefore, they are known as seafarers, and a National Welfare Board is created. So, for the welfare or to provide welfare schemes or to incorporate welfare policy measures, etc., for these seafarers, or you can say in common parlance crew members of the ships, what are the different beneficial measures and policy decisions that can be taken. This particular National Welfare Board for Seafarers is responsible for all these aspects. Apart from the above institutions, another statutory organization is the Seamen's Provident Fund Organization, which has been set up under the Seamen's Provident Fund Act 1966. Now, let us talk about National Shipping Board. What are the objectives and functions of National Shipping Board? The National Shipping Board has been set up as the highest advisory body on matters related to Indian shipping fraternity, including its expansion, liberalization policies, development thereof, and to advise on such matters arising out of the Merchant Shipping Act 1958. As early in 1947, the establishment of such institution was recommended by the Reconstruction Policy Subcommittee. The ship owners too urged to have such body in existence. In 1958, when the merchant shipping law was revised and consolidated, the opportunity was taken to provide for creation of such permanent statutory authority called the National Shipping Board. Consequent upon the efforts from all quarters of the shipping fraternity, the National Shipping Board came into existence on 1st March 1959. Now, what is the constitution of the board? If we look at the constitution of the board, we will see and realize that the members of the board come from legislative body, that is the parliament, and they somehow represent the interests of shipping community, as well as they also take into account the interests of the seafarers to a certain extent while framing larger policies, and they also take into account the interest of the nation at the same time. So, if you look at the constitution of the board, under the provisions of section 4 sub rule 2 and 3 of the Merchant Shipping Act 1958, the constitution of the board is as under. Firstly, there are 6 members elected by parliament, 4 by Lok Sabha from among its members, and the other 2 by Rajya Sabha from among its members. So, we can see that in a general parlance, the party that is in majority would generally be in a position to refer its parliamentarians, 4 parliamentarians from Lok Sabha, 2 parliamentarians from Rajya Sabha, to be representing the National Shipping Board and frame policy as far as shipping activities are concerned. And therefore, they represent the central government, ship owners, seamen, and such other interests as in the opinion of the central government ought to be represented on the board. There shall be such numbers of other members not exceeding 16 as the central government may deem fit to appoint on the board. Under the provisions of section 4 clause 3 of Merchant Shipping Act 1958, the central government has the power to nominate one of the members of the board so constituted in the above manner to be the chairman of the board. The National Shipping Board shall be established for a period of 2 years at the first instance, and thereafter it shall be re-established at the end of every 2 years. So, there is reconstitution that takes place after every 2 years as far as the constitution of National Shipping Board is concerned. So, members can be changed also after 2 years, the whole constitution may be changed, but the quantitatively it will remain same, but this person who are representing the ship owners or seamen or the government, central government of India, they may be the representation could be changed. Now, general assessment. In order to highlight various problems which are being faced by Indian shipping from time to time, the advice of National Shipping Board has been of immense importance. So, we see that when it was established, the concerns and considerations with respect to construction of ship, with respect to rules and regulations as far as safety and navigational aspects are concerned, were very different. And if you come 50 years after that, we see that a lot has changed as far as construction of ship is concerned, or as far as safety requirements or equipment requirements of ships are concerned. So, as with the passage of time and with the advent of time, as science and technology develop, the legal requirements change, the concerns of the world change, then we see that as the requirements of the shipping industry and shipping regime changes of the world, accordingly this board will make suggestion in order to keep India updated as far as its implementation of shipping policies are concerned, which may be with respect to again safety, navigation, protection or welfare of the seafarers, etc. In such scenario, it may also take into account the interest of the ship owners as well. We need to also protect ship owners, because if heavy liabilities are imposed upon ship owners, the shipping industry might collapse and it might be at risk. So, in order to protect the interest of the ship owners also, since it is a heavy investment transaction or business, protection of ship owner is also a necessary aspect. So, what should be the policy with respect to liabilities to be imposed upon the ships or ship owners in case any damage has occurred? So, policies with respect to all those aspects come within the domain of National Shipping Board. Therefore, we say that in order to highlight various problems which are being faced by Indian shipping from time to time, the advice of National Shipping Board has been of immense importance. Some of the matters like fixation of the plan targets for shipping tonnage, what kind of ship can carry what weight of what should be the amount of weight that a particular ship could carry. So, tonnage is the amount of weight or amount of cargoes that a particular ship can carry. The permission to carry a certain amount of cargo or tonnage is given by the appropriate authority which functions under the central government. So, therefore, if the authority allows for let us say 1000 tons, 150 tons or 100 tons, only that much of tonnage would be carried. If it does not carry the appropriate certificate to carry a certain amount of weight, then it will be violating the rules and regulations pertaining to shipping in India. And therefore, to identify the nature of ship, or you can say the whole structure of the ship, whether the ship can carry a certain amount of tonnage or not, will be decided by the appropriate authorities functioning under the directions or guidelines of the central government, which also functions under the authority of, or you can say directly through DG shipping. So, here the fixation of plans targets for shipping, the limit of foreign participation in Indian shipping companies, the quantum of development rebate for Indian shipping and the problems of the sailing vessels industry could be solved with due consultation and the recommendations by this body to the government. So, in general, on all matters like development of coastal shipping and such other related matters for supporting India's trade, this statutory organization is rendering the services in solving the above narrated subject. So, what should be the amount of investment as far as foreign investment is concerned into the shipping? If there are multiple owners of a particular shipping company, what number of owners could be Indians, or even if they are not Indians, what should be the holding as far as investment in the shipping transaction or shipping business of a particular company is concerned. Rules pertaining to all of that particular aspect are decided, or you can say advised by National Shipping Board, and they are done with the objective that India's interest is not compromised at any cost. Further, we have another board which is National Welfare Board for Seafarers. Under the provisions of section 218 clause 1 of the Merchant Shipping Act 1958, the National Welfare Board for Seafarers has been established or set up by the Government of India for advising them on the matters and measures to be taken for promoting the welfare of seamen, whether ashore or on board the vessel, irrespective of the fact that they are travelling away or they are still on board near to the coast. Irrespective of that particular aspect, this particular body, that is National Welfare Board for Seafarers, can make rules, can take appropriate measures as far as welfare of the seamen is concerned. And generally and in particular, following are the areas over which the board can take decisions as far as welfare of the seafarers are concerned. And they are establishment of sailors' home or boarding and lodging houses for seamen, establishment of libraries, recreations room, cafeteria, clubhouses and such other welfare amenities for the social and cultural development of seamen, establishment of hospitals, nurseries, rest houses, holiday resort as well, easily availability of medicines for offshore seamen at home or off article, establishment of free reading books for upgrading educational standard and such other related facilities at home if they are off articled seamen. So, we see that almost all the basic necessities that are required as far as a seafarer or seaman is concerned are to be ensured by the National Welfare Board of Seafarers in general by making certain policies. Implementation of the policy would certainly come through DG Shipping from the directions of central government, but this is a board which makes policies and advices on certain matters as we had already identified, which are related to boarding and lodging with respect to their health, with respect to medicines, with respect to recreational activities. So, all of which is to be taken care as far as seamen are concerned. Now, the constitution of the National Welfare Board for Seafarer is that the board is headed by the Union Minister of Ministry of Surface Transport, New Delhi, and comprised of members of parliament, representatives of concerned ministries of Government of India, maritime state governments, port trusts, ship owners, seafarers, merchant navy officers, voluntary societies and such other statutory bodies, autonomous organizations dealing with the social welfare activities, like for example, we can take the example of Tata Institute of Social Sciences. So, the constitution is quite broad enough, it takes care the stakeholder from all the necessary areas, which may be the interest of the ship owner, which may be the interest taking into account of the seafarers and seamen. Government representation is also present as far as the board is concerned. The tenure is again the same as that of National Shipping Board, and that is 2 years. The general assessment, or as far as the working is concerned of the board, is that on 4th June 1956, the inaugural activities were commenced, wherein various recommendations were made in respect of seamen's welfare, some of which have been narrated here below, and they are: institution of welfare levy on ship owners for providing a continuous flow of revenue for financing seamen's welfare program, formation of seamen's welfare fund society for financing welfare activities for seamen. Since we see the act of being a seaman is to an extent risky, the person who becomes a seafarer keeps his or her life at risk while traveling from one part to another part, and keeps himself or herself away from home for a longer period of time. So, taking lot of such aspects into account, we tend to ensure through these boards that welfare schemes and welfare mechanism is in place as far as the seafarers and seamen are concerned, and therefore, there is formation of Seamen's Welfare Fund Society also, which finances welfare activities for seamen. Observance of Merchant Navy Flag Day and National Maritime Day in commemoration of personnel rendered their services for the cause of shipping fraternity. We also see that there is a fund out of which the family members can also be supported. We also see that once seafarers are no more seafarers, but they have rendered their precious lifetime to seafaring, then they also should be benefited through these funds. Establishment of hostel cum club for seamen at Mumbai, Calcutta, Madras. Provision of medical treatment of off-articled seamen. Introduction of social security measures like Seamen's Provident Scheme and Seamen's Gratuity Scheme. Now, friends, we have talked about two important boards, that are the policy making boards as far as shipping activity is concerned, or as far as crew members are concerned, that is the seafarers. We will now talk about two other important topics, subtopics you can say, nationality of a ship and then registration of a ship. When we talk about the nationality of the ship, it is the similar kind of nationality that an individual gets. The only difference that we see here is with respect to the subject matter. In individual's case, individuals are natural persons, ships are not natural persons. However, for the purposes of protection and advantages that a ship must get, a similar kind of structure has been created in order to endow a ship with nationality. And when we say a particular ship belongs to a particular nation, that means it can raise the flag of that particular nation, or vice versa. If it is raising the flag of a particular nation, it can be identified that a ship belongs to that particular nation. So, for nationality of a ship, there has to be a genuine link between the ship and the state to claim nationality of the ship. Now, why do we say that there has to be a genuine link? Generally, in today's time or modern times, we see that wherever the ship gets registered, it automatically gets the nationality of that particular state. But at the same time, we can say that if there is a doubt with respect to nationality of the ship, a ship maybe is registered at two different states, for example, and if a dispute arose as to the claim to be brought before that particular ship, which jurisdiction will be applicable or what laws will be applicable as far as that particular ship is concerned. Whether ship is seaworthy or not seaworthy will be identified from the laws of the place where the ship is registered. And if the laws of the place are not up to the mark, or you can say international standards, or up to the standards of the place where the damage has occurred, or let us say if the ship is registered at two different places, where at one place the requirements of the registration are not up to the mark of international standards or the general practices standards, or they are lower as in comparison to the practice of different other states. So, when such situation comes into being, and at the same time the same ship is having registration in other parts, wherever it is allowed that a ship can be registered at two different places, how to identify in such situation that from which state a particular ship belongs to? So, we need to identify that there has to be a genuine link. And how do you identify the genuine link? Certain relevant facts that can be taken into account could be the nationality of the owner perhaps, or the place of business of the owner. It may be a company where the company is registered or where the company's place of business is in existence. So, through various different relevant facts, if such issue comes into being, we can tend to identify the actual nationality of a particular ship. And therefore, when we look at the convention pertaining to nationality of ship, we see that Article 91 of the 1982 convention, that is the United Nations Convention on Law of the Sea, we see that every state shall fix the conditions for the grant of its nationality to ships, for the registration of ships in its territory. So, as I have already told you, once registration is in place or mechanism is in place, then through registration a ship gets the nationality. And for the right to fly its flag, ships have the nationality of the state whose flag they are entitled to fly, and this entitlement will automatically come only if the ship is getting registered. There must exist a genuine link between the state and the ship. And why this particular last line has been added is because certain problems had come into being where ship was constructed in state A, the ship owners are residing in state A, the business is carried out through state A, but the registration is taking place in state B, for the very basic reason that the requirements of registration in state A are higher and are difficult to be taken into account, whereas in comparison to state A, state B has a lower standard of lower requirement as far as registration of ship is concerned. So, it will be convenient for the company or the owners of the ship to get that particular ship registered in state B, but it creates a lot of risk as far as the marine environment is concerned, as far as the cargoes and life at sea are concerned. So, it raises questions as to the seaworthiness of the ship. So, in such situations we must establish the genuine link, but it becomes very difficult. It still remains to a larger extent an unresolved aspect, because if a ship is registered to a particular state, in a particular state, then certainly it will carry the flag of that particular state and it will be deemed to be the ship of that particular state. Secondly, every state shall issue to ships to which it has granted the right to fly its flag documents to that effect. So, wherever it is registered, certain necessary documents will be supplied to that particular shipmaster, and shipmaster will always carry those particular documents which will establish that whether the ship is registered in country A or in country B. Article 92 of the UNCLOS says or talks about status of ships. Ships shall sail under the flag of one state only, and save in exceptional cases expressly provided for in international treaties or in this convention, shall be subject to its exclusive jurisdiction on the high seas, which we say flag state jurisdiction. A ship may not change its flag during a voyage or while in a port of call, save in the case of a real transfer of ownership or change of registry. If the ownership changes or if the place of registration changes, now the ship gets registered in, let us say, in some other country, or if the ship has been sold to any other owner situated in any other country and the new owner registers it in different country, then in such a situation only we can say or see the change of flag. Otherwise, the same flag should be put upon the mast. A ship which sails under the flags of two or more states, using them according to convenience, may not claim any of the nationalities in question with respect to any other state, and may be assimilated to a ship without nationality. So, UNCLOS makes it very clear, because such were the practices in the past, that ships get registered in different nationalities in order to take benefit in different regions wherever they reach out. So, UNCLOS had made it clear that now if you register in more than one state, then in such a scenario any of the nationality will not be accepted. National character and flag. Now, the Merchant Shipping Act also talks about the national character and flag. In section 63 says national colors of Indian ships. The central government may, by notification in the official gazette, declare what shall be the proper national colors for all ships registered under this act, and for all ships which are not so registered, but which are owned by the government or by any local authority or by any body corporate established by or under any law for the time being in force in India, or by a citizen of India, and different colors may be declared for different classes of ships. Any commissioned officer of the Indian Navy or any customs collector or any Indian consular officer may board any ship on which any colors are hoisted contrary to this act, and seize and take away the colors which shall be forfeited to the government. So, we see for the different types or nature of the ships, different colors are engaged, and if there is any violation that is identified by the appropriate authorities, the ship can be forfeited and its color can be taken away. Section 64 talks about unlawful assumption of Indian character. No person on board a ship which is not an Indian ship shall, for the purpose of making it appear to be an Indian ship, use the Indian national colors, unless the assumption of Indian character has been made. Now, the burden of proving will lie or shall lie on him, for the purpose of escaping capture by the enemy or by a foreign ship of war in the exercise of some belligerent right. Section 66 talks about Indian ships to hoist proper national colors in certain cases. An Indian ship shall hoist the proper national colors on a signal being made to her by any vessel of the Indian Navy, on entering or leaving any foreign port, if of 50 tons gross tonnage or more, on entering or leaving any Indian port. Further, section 67 talks about national character of ship to be declared before clearance. A customs collector shall not grant a clearance for any ship until the master of such ship has declared to that officer the name of the country to which he claims that she belongs, and that officer shall thereupon inscribe that name on the clearance. If a ship attempts to proceed to sea without such clearance, she may be detained by any customs collector until the declaration is made. Further, as far as liabilities are concerned, for any wrongful act or any act which is in contravention with respect to the nationality part is concerned, then section 68 says liabilities of ships not recognized as Indian ships. Where it is declared by this act that an Indian ship shall not be recognized as such, that ship shall not be entitled to any privileges, benefits, advantages or protection usually enjoyed by Indian ships, or to use the Indian national colors for Indian ships, or to assume the Indian national character. But so far as regards the payment of dues, the liability to fine and forfeiture and the punishment of offences committed on board such ship or by any person belonging to her, such ship shall be dealt with in the same manner in all respects as if were a recognized Indian ship. Now, section 69 talks about proceedings on forfeiture of a ship. A forfeiture will take place again if the acts of the ship are in contravention to the rules and regulations levied down under the Merchant Shipping Act. Where any ship has either wholly or as to any share therein become subject to forfeiture under this part, any commissioned officer of the Indian Navy, any commissioned officer of the Indian Navy, any customs collector or any Indian consular officer in the scenario where the ship is not in Indian port or near to Indian waters, but is away from India in some other foreign territory, then in that case Indian consular officer or any other officer authorized by the central government may seize and detain the ship and bring her for adjudication before the High Court, and the High Court may thereupon adjudge the ship with her equipment to be forfeited to the government and make such order in the case as to the High Court seems just, and may award to the officer bringing in the ship for adjudication such portion of the proceeds of the sale of the ship or any share therein as the High Court thinks fit. Now, talking about nationality, we must talk about now registration, since it is only through registration that a ship assumes the aspects of nationality. As far as registration of ships in India is concerned, a ship entitled to fly the flag of a country needs to be registered in that country. The object of registration is to ensure that persons who are entitled to the privilege and protection of the Indian flag get them. The registration affords evidence of title of the ship to those who deal with the property in question. It also gives protection to the members of the crew in case of casualties involving injuries or loss of life, to claim compensation under the provisions of the Indian acts in Indian courts. So, you get benefits with respect to compensation and other types of benefits only if the ship is registered in India. So, benefit will flow from India or Indian authorities or under certain funds only if it is registered. So, registration becomes a very important aspect. Therefore, Indian Merchant Shipping Act of 1958 for the first time dealt with registration of ships. Earlier acts had lacked this aspect totally. Part 5 of this act deals with exclusively with the registration of Indian ships. Now, why did it lack exclusively is because for the very obvious reason that ships were getting registered under the British regime. So, they were considered to be British ship per se, even if they were Indian ships for that matter. So, part 5 of this act deals with exclusively with the registration of Indian ships, while part 15 deals with registration of sailing vessels and part 15A deals with the registration of fishing boats. So, different classifications have been made out as far as registration of ships and boats are concerned. Ships which qualify to be registered are required to be registered only at ports designated as ports of registry. At present, Mumbai, Calcutta and Madras, and surveyor in charge of Cochin and Murmagaon have been notified as registrar of Indian ships. In their capacity as registrar of Indian ships, the principal officers are required to maintain a complete record of ships on register, indicating the status of the ship on a particular date. A central register is maintained by the Director General of Shipping, or you can say DG of Shipping, which contains all the entries recorded in the register books kept by the registrar at the port of registry in India. So, a book maintains the complete record of all the ships that are registered at the Indian port. The DG of shipping, at the request of owners of Indian ships desiring to be known as at sea, allots signal letters and controls the series that may be so issued. Certain formalities are required to be complied with before a ship is registered as an Indian ship, and these are laid down in the Merchant Shipping Rules 1960 as amended from time to time. Now, as far as the status of Indian ship is concerned, the conferment of a status of Indian ship is restricted to ships owned by a citizen of India, ships owned by a company or body established by or under any central or state act which has its principal place of business in India, ships owned by a cooperative society which is registered or deemed to be registered under the Cooperative Society Act 1912, or any other law relating to cooperative societies for the time being in force in any state. So, these are the bodies that can go for registration of a ship. Qualifications that are required for registration as Indian ship would be that a sea-going ship fitted with mechanical means of propulsion of 15 tons net and above, howsoever employed, and those of less than 15 tons net employed otherwise than solely on the course of Indian, qualify for registration under Part 5 of the Merchant Shipping Act. I repeat that a sea-going ships fitted with mechanical means of propulsion of 15 tons net and above, howsoever employed, and those of less than 15 tons net employed otherwise than solely on the course of Indian, qualify for registration under Part 5 of the Merchant Shipping Act 1958. Ships so registrable are required to be registered only at ports designated as ports of registry, which we have already discussed in the previous slide. In their capacity as registrar of ships, the principal officers and concerned surveyors in charge are required to maintain a complete record of ships on register, indicating as on a particular date the persons either in their individual capacity or as joint owners or as a corporate body who have a stake in the ownership of ships. Not more than 10 individuals are entitled to be registered as a owner of a fractional part of a share in a ship, but a maximum of 5 persons could be registered as joint owners of a ship or of any share and shares therein. Joint owners by reason of the position as such cannot, however, dispose of in severalty any share or interest therein. So, since it is joint interest, it will remain in joint, individually it cannot be taken out. Formalities to be observed for registration as Indian ship. The owner of a ship wishing to have it registered at a port in India has to submit to the concerned registrar. Firstly, a declaration of ownership in one or the other prescribed forms as may be applicable, depending upon whether he is a sole proprietor, joint owner or a company made before a registrar, justice of the peace or an Indian consular officer. Secondly, a certificate signed by builder, that is builder's certificate wherever the construction has happened, may not be in India, may be in some other country, but a certificate by the builder who has constructed the whole ship, of the ship containing a true account of the proper denomination and of the tonnage of the ship as estimated by him and the time when the place where the ship was built. So, what is the weight of the ship, when it was built, and other details with respect to its attachments and equipments also are to be mentioned in the certificate by the builder. So, that particular certificate must also be submitted. The instrument of sale under which the property of the ship was transferred to the applicant who requires it to be registered in his name, especially for second hand ships. To give a minimum of 14 days notice to the registrar of the name proposed for the ship. The registrar, before registering the vessel in the name of the applicant, shall obtain prior approval of the name from the DG shipping, who will also allot an official number of the ship, and a name of the ship is also registered. On being satisfied that the ship, on the strength of the evidence placed before him, is entitled to be an Indian ship, the registrar arranges for survey of the ship by a surveyor for the determination of her tonnage in accordance with the Merchant Shipping Rules 1987 as amended from time to time for the purpose of issue of a certificate of survey. After the formalities enumerated above have been gone through, the registrar issues a carving and a marking note. So, sign is placed upon the ship. This note is to be returned to the registrar after carving and marking have been duly carried out on the ship in the prescribed manner and certified by a surveyor. The carving and marking involves the carving of the name of the ship conspicuously on each side of her bows, as well as insertion permanently on her stern the name of the intended port of registry. On completion of the preliminaries to registry as described in the preceding paras, the registrar enters the particulars of the ship such as name of the ship and the port to which she belongs, details contained in the surveyor certificate, particulars respecting her origin as revealed in the declaration of ownership, the name and description of her registered owner, and if there are more owners than one, the number of share owned by each of them, and the name of the master in the registry book. The registrar issues thereafter to the owners a certificate of registry retaining the surveyor certificate, builder's certificate, instrument of sale by which the ship was sold, and the declaration of ownership. So, a complete detail is then mentioned in the registrar, and it keeps with himself or herself the documents pertaining to the ships. Formalities connected with registration of an Indian ship when acquired abroad. When a ship is built or acquired out of India and becomes the property of a person qualified to own an Indian ship, the owner or the master of the ship will have to apply to the Indian consular officer at the nearest port for the issue of a provisional certificate. So, a provisional certificate will be issued by the consular situated abroad, and that provisional certificate will work for the next 6 months or till it reaches to the Indian port for a fresh registration, since the registration provided by the Indian consular is only provisional in nature. The certificate of registry has to be used only for the lawful navigation of the ship and is not to be detained by reason of any lien, mortgage of interest whatsoever claimed by any party. Anybody having possession of the certificate of registry has to make it over to the person entitled to its custody, as otherwise he becomes liable for being summoned before a magistrate and examined on the issue touching his refusal to surrender the certificate to the one entitled to it. No change in the name already in the registry is permitted except in accordance with the procedure laid down in the Merchant Shipping Registration of Ships rules as amended from time to time. Application for the registry of alteration to a ship will have to be made to the registrar within a month of alterations, and there are certain other minor rules and regulations that are to be followed as far as alteration with respect to name, tonnage, etc. are concerned. Now, transfer or acquisition of an Indian ship or interest therein. Now, as per the amendment to section 42 of the Merchant Shipping Act, no prior permission from the DG Shipping is required for creation of any mortgage on a ship except during the period when the security of India or any part of the territory thereof is threatened by war or external aggression. Similarly, the DG Shipping's prior approval for the sale of the ship is not required, provided all wages and other amounts due to the seamen in connection with their employment on that ship have been paid in accordance with the provisions of this act. Secondly, the owner of the ship has given notice of such transfer or acquisition of the ship to the DG. Now, as far as transmission of an Indian ship or interest there is concerned, we see that where the property in an Indian ship or share therein is transmitted to a person on the death or insolvency of a registered owner or by any lawful means other than a transfer described as above, it would be effected by an application made to the registrar of ship's port of registry, accompanied by a declaration in the prescribed form identifying the ship and also a statement of the manner in which and the person to whom the property has been transmitted. In the case of transmission consequent on insolvency, a declaration of transmission has to be accompanied by proof of such claim. Now, as far as the registry of government ships are concerned, similar approach is taken into account, and the DG of shipping has to maintain all the records, and with respect to other aspects pertaining to registration, the rules have been mentioned in Merchant Shipping Act Part 5, and we can in detail cover up that the listeners can in detail cover up that particular aspect. The essential aspects pertaining to registration and nationality have already been discussed. So, I thank you for your patient listening this particular lecture. Namaskar.